Welcome back. In our last few lessons, we have looked at the who and the what of your financial power of attorney. We have identified your agent and the different forms a financial power of attorney can take. But today, we are going to focus on a question that is just as important. When does that authority actually start? By the end of this video, you should be able to explain the difference between immediate authority and springing authority, and why people may choose one over the other. In the world of POAs, this choice usually comes down to two options: an immediate power or a springing power. Each path has its own set of advantages and potential hurdles, and your goal is to determine which one aligns with your personal values and your specific family dynamics. Let's start with immediate authority. As the name suggests, an immediate power of attorney becomes effective the moment you sign the document. This doesn't mean you are losing control of your money or that you are handing over your independence. It means the agent has authority from day one. However, as long as you are competent, you remain the boss and can overrule any decision your agent makes. It simply means that your agent has the legal key in their hand right now. One of the best advantages of immediate authority is speed. If life suddenly takes a detour, maybe you are in an accident or face a sudden medical crisis, your agent can step in instantly to pay the mortgage, handle insurance claims, or manage your business. There's no waiting period, and no need to provide extra proof to a bank or an investment firm. For many people, this provides the ultimate peace of mind because it eliminates the risk of a management gap where bills go unpaid while your agent is working through red tape. However, some people feel a bit uneasy about giving that much power away while they are still healthy and able to handle things themselves. They worry about the potential for misuse or simply prefer a higher level of privacy. Individuals with these concerns often consider the second option, which is springing authority. A springing power of attorney is like a security system that is currently turned off. It only springs into action when a specific triggering event occurs. The most common trigger is a determination that you have lost your mental capacity. This usually requires a written certification from your primary physician, often following a personal examination, stating that you're no longer able to manage your own financial affairs. On the surface, a springing power feels like the safer choice because it acts as a safeguard against premature use of your authority. It ensures that your agent can only act when it is truly necessary, but it is vital to understand the trade-offs. Because this power is conditional, your agent must provide proof that the trigger has occurred when they try to use the document. This is where things can get complicated. Financial institutions are often very hesitant to accept a springing power of attorney. They may worry about the validity of the doctor's letter, or whether the specific legal definition of incapacity has been met according to their internal policies. This can cause significant delays during a crisis. While your agent is trying to get the right signatures from a doctor, those gears we talked about, your bills, your taxes, and your contracts, could be grinding to a halt. If you decide that the safeguard of a springing power is right for you, the next step is to design the trigger with care. You aren't limited to a single doctor's opinion. You could customize the instructions to require a letter from 2 different physicians, or even a certification from a majority of your adult children alongside a doctor's statement. For example, you might write that the power only starts if your spouse and your attending physician both agree in writing that you need assistance, adding a layer of family oversight to the medical determination. It is worth reflecting at this point. If a springing structure feels necessary because of reservations about an agent's judgment or trustworthiness, it may be worth reconsidering whether that individual is the right person to act on your behalf. So let's explore examples of each. Let's say Maria is healthy and independent, and she names her sister as her financial agent with immediate authority. Nothing changes day to day. Maria still pays her bills and manages her accounts like she always has. Then one afternoon, Maria is in a car accident. She's expected to recover, but she's in the hospital for 2 weeks and can't keep track of paperwork or phone calls. While she's resting, her sister is able to step in right away. She talks to the insurance company, pays the rent, and handles a time-sensitive work reimbursement that would have expired. When Maria comes home, everything is still in order. No missed payments, no late fees, no emergency scrambling. The authority didn't take over Maria's life. It quietly filled the gap while she needed help. Now imagine David. He's very private and cautious. He likes the idea that no one can act for him unless it's clearly necessary, so he chooses springing authority. Years later, David has a medical event that affects his memory. His daughter knows she needs to step in to manage finances. First, she has to show that the trigger has been met. She schedules a doctor's appointment, waits for written confirmation, and then sends that documentation to the bank. The authority activates, but not instantly. A few payments are delayed while paperwork is reviewed. Nothing disastrous happens, but it takes time and persistence. For David, the extra steps were worth it, because the authority only started when it truly had to. And here's a point to remember. Your POA should have backup agents in case the first can't serve. In these cases, you can mix and match for a fit that works for you. For example, you can structure it to be an immediate authority if your spouse is serving. And then, if your spouse cannot serve, it is springing. Here is the perspective shift for today. Choosing immediate authority is often seen as a gift of efficiency, making your agent's future job as simple as possible. Whereas, choosing springing authority is often seen as a protective boundary for you, principal. By watching this video, you have already gained the clarity to look past the legal labels and see the practical reality of how these documents work. You now know that speed and safeguards may be on opposite ends of a scale, and you are the only one who can decide where the balance should sit. If you're ready for a small immediate step, I invite you to think about your current level of comfort. If you had to sign your power of attorney today, would your biggest worry be the risk of someone acting too soon, or the risk of them being delayed when you need them most? Just naming that primary concern is a huge move toward a solid decision. You can even use the MyEstateKit app to select your preference and start exploring the different trigger styles that might work for you. For those who want to go deeper, we have further resources exploring springing and immediate in the resource section, along with tools to help you visualize the steps your agent would have to take in either scenario. For now, you've tackled an important and often overlooked question, not just who helps, but when they're allowed to help. And that timing can make all the difference.